Prenuptial agreements. We've all heard about those. They are agreements that are made between a couple who is planning to get married regarding what will happen to their property in the event they get a divorce or one of them dies. But what happens if after a couple gets married, they think we should really divide this property now, before divorce or before death? And can we do that? And the answer is yes. There are various agreements, but most notably called a post-nuptial or a marital agreement. And under the marital agreement, a couple can sit down and decide that in the event of death, in the event of a divorce, the property they have that they brought to the marriage, property they got after they were married, will be divided in a certain way. Well, that brings us to this week's case. It involves a couple in Massachusetts. They were married, been living together for some period of time. He, husband, had $5 million in Florida real estate. He, husband, wasn't happy with where the marriage was going, and he, husband, approached his wife and said, you know, this isn't going well, sweetheart, but I want to try and make it work better, and I feel, gee whiz, I'm just really being pressured by our situation. I think I'd be much better off if I knew that $5 million in property was going to be mine in the event we got a divorce. Well, they each got their separate attorneys. Each of the attorneys for them worked out an agreement, and under the agreement, it was stated that he, husband, would have the $5 million in Florida property in the event of a divorce or of a death. Well, a divorce took place. Wife said, wait a second, this is a bad deal. This is a bad deal, and this is not enforceable. This contract's not enforceable because it's against public policy. It's against public policy for a variety of reasons, but in this case, it's really against public policy because it was a coercive agreement. I was pressured into signing this thing because I wanted the marriage to hold together. He said it was going to be going better if he could be sure he could hang on to this $5 million in property, and therefore I signed it. And moreover, it's an illusionary agreement. There was no consideration. I didn't get anything out of this deal. I mean, I had marital property. I had an interest in the $5 million property there in Florida, but now I gave it all up and I got nothing in exchange. Therefore, it cannot be enforced. Went all the way up to the Massachusetts Supreme Court, and there the Massachusetts Supreme Court said, hey, unfortunately, you, wife, are out of the picture. You're gone with regard to that $5 million in Florida property because the agreement is enforceable. It's enforceable because each of you went to your own separate lawyers. Those lawyers worked out the agreement. There was nothing indicated in that agreement that this was anything other than an arm's distance transaction, and therefore it is enforceable. So what's the lesson learned here? The lesson learned here is very simple. And that is that if you're in a marriage, you're concerned about property, you can work out the details of that in a marital agreement. But there are certain conditions that must be fulfilled. And the most important condition is that each of the parties has to be represented fairly. That means generally that each of the parties needs to have their own lawyer, and the lawyers need to work that out, looking after the interests of each of the parties they represent. And if it's done in that way, there's a good chance that it can be enforced. Is there a guarantee of enforcement? Not necessarily in all states, but at least there is a good opportunity for that agreement to be enforced. What do you need to be aware of? You need to be aware of that this can be done, and when you enter this kind of agreement, you have to do it with your eyes wide open. Okay, this is the lesson the law brings us this week. Every week the law brings us lessons. We bring them to you on our video blogs so you understand how the law works and make that law work for you. I'm David Allen.